Welcome to Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Karlan, along with Joe Bankman.
Pam, the state of Texas is now in a lawsuit against a federal law. And it's an interesting suit. At issue is whether a child can be adopted by foster parents, which the state of Texas argues, or whether a federal law called the Indian Child Welfare Act requires that the child first be placed for adoption with a Native American tribe. And what's at issue, of course, is this child would be or is a member of that tribe.
Because his biological parents, one of his biological parents was a member of the tribe, right?
That's right. So this pits Texas, which is arguing that this federal law is a racial classification and unconstitutional, among other arguments they make, against a desire to respect the integrity of Native American tribes.
Well, and we have with us today, Joe, some guests.
Our first guest is Greg Ablavsky. Greg joined our faculty in 2015. He has a JD, a law degree, and a PhD in history from the University of Pennsylvania. His specialty is the West and issues regarding Native American sovereignty. Fun fact about Greg, he also likes eating unusual regional food, often with the mystery ingredient, from what I can see, of Spam. So
that's more Hawaiian than anything else.
Well, Greg is learned on this as in other things. And maybe, Greg, one day we'll have you to give us a little guide of regional food. But today you're going to help us look at this issue.
And joining us as well is Jared Crum. Jared is a third-year student at Stanford Law School. He's co-president of Stanford's Native American Law Student Association, and he's also one of Greg's students and has been involved in a number of pro bono projects related to tribal rights. So thank you both for coming.
Our pleasure. Thanks for being here. Thanks for having us here.
So let's get back to the case that Joe was talking about, the Brackeen against Zinke lawsuit. How do lawsuits like this come about, and what's the law that's driving the litigation here?
So to understand the Indian Child Welfare Act, we have to go back, as is often the case in this area of law. Not so far back, not all the way back to the 1700s, which is often what I end up doing, but back to the 50s and 60s when there really was an epidemic of state social services coming in and taking away children out of Native homes. In some states like South Dakota, North Dakota, something like half of Native children were actually being taken away from their birth parents and being placed with non-Native families. And a lot of that had to do with the failure to understand Native culture, the idea that, the child might be with an aunt or grandmother, and that was normal in Native culture. They saw that this was not, in fact, a nuclear family and thought this was a harm that needed to be remedied. And so Congress stepped in 1978 and passed the Indian Child Welfare Act, which explicitly attempted to remedy this problem. And the Indian Child Welfare Act has a number of provisions, but I think the key thing to note is that it gives a lot of the jurisdiction over cases of Indian children, which is a term of art in the statute. These are children who are either eligible for membership of the tribe or are members themselves. It gives primary jurisdiction over those adoption decisions to tribal courts.
And so that's different than the usual run-of-the-mill where it's state courts that decide custody issues for children or decide adoption and like. And we have this terrible history in the United States that goes back also to what were called the Indian schools, where children were taken away and sent across the country. I mean, Jim Thorpe is probably the most famous example that people have heard of. And they were given new names and they were given new religions and their hair was cut and they were forced to wear Western clothes. So what caused Congress finally to start caring about this?
Well, there was a moment of tremendous change that happened really in the 60s and into the 1970s when we enter what is often described as the era of self-determination. That was after really centuries of failed federal policies that attempted to assimilate tribes, like the boarding schools that you described, Pam, or in the 1950s, a policy that was called even termination, that involved extinguishing tribal sovereignty altogether. Through tremendous native activism, many people might be familiar with the occupancy of Alcatraz. Through the native activism, they were able to push the federal government to change its policies and adopt a policy in which native peoples would decide for themselves the course and future that they would have. And so the Indian Child Welfare Act was part and parcel of this important historical moment.
So in the facts of this case, Greg, what tribes are involved and what do they say and what does Texas say?
So the particular tribe that the child is eligible to be a member of here is the White Earth Ojibwe, which is actually a tribe up in North Dakota. But the Navajo Nation and other tribes have intervened in the case. And they're really seeking to protect this law, which they see as a bulwark on protecting tribal sovereignty and the integrity of their relationships with their members and their families. Now, Texas has taken up a position that has become increasingly widespread. We first saw this in Arizona, where a conservative think tank called the Goldwater Institute launched a litigation effort against the Indian Child Welfare Act. And it's really a two-pronged strategy, both of which are based in the U.S. Constitution. One is the argument that Congress doesn't have the authority to enact this under the Indian Commerce Clause, and I think we're going to talk about that a little bit later. But the other argument is that because this statute distinguishes this class of children called Indian children from other children, it is in fact based on a racial classification. And as Pam, as you both know well, racial classifications get strict scrutiny under federal law, which would make it harder for this statute to survive.
And you filed an amicus brief in this case, or what's your position?
So I've done some historical research on actually both of these questions, both about the scope of federal power and about this question of racial classifications. So the amicus brief that I filed with a number of other federal Indian law scholars focuses on that first question about the scope of federal power. But I've also done some recent research on from the 18th century, around the time of the drafting of the Constitution, about classifications as Indian.
And is it racial? Is it something else? What do you conclude?
Well, to understand that, we have to go back to a case that predates the Indian Child Welfare Act called Morton versus Mancari from the 1970s. And in Morton versus Mancari, there was a very similar challenge that was happening to a classification as Indian, in this case for the purposes of hiring at the Bureau of Indian Affairs. And there, the Supreme Court said that because this classification is directed toward people who are members of a federally recognized tribe and not all people who might be considered racially Indian, it was a political, not a racial classification, and therefore it didn't get strict scrutiny. It merely had to be tied to Congress's trust responsibility toward Native peoples.
This is Stanford Legal, and today we're talking with Greg Ablavsky and Jared Crum about contemporary issues involving Native Americans and constitutional law. And Jared, I wanted to bring you into the conversation to, Greg was just talking about his amicus brief, and you've been working on something called an amicus brief project. Could you tell us a little bit about that?
That's right. The Native American Rights Fund, which is one of the big legal organizations that advocates for Native people's rights around the United States, has a Supreme Court project. And one of the things they like to do is have law students around the country look in the lower federal courts, see what Indian law cases are pending, what cases could potentially present interesting or important issues, and put it into a database for the project, because the project has a lot of work to do, but it's not the most well-resourced area of the legal world, and it's not the most well-resourced thing not the most well-resourced advocacy group. So it's important to have students there so that they can research and see what cases are pending. So
and know a little bit about the cases before they get so far along that people like Greg can't even step in to try and help out.
That's right. I think as Professor Ablavsky alluded to, there's a lot of other groups out there that are also interested in Indian law, and they have a different agenda than tribes necessarily do, and they have a different goals than tribal sovereignty. So the sooner that NARF and the sooner that the Indian law community can look at these cases and see what's coming down the pike, the better.
Jared, what has this meant to you to do this? I want to put you on the spot here a little bit. Stanford law students have lots of opportunities. You're spending your time with this.
It's important to me because I am a member of a federally recognized Indian tribe. I'm a member of the Kickapoo tribe of Oklahoma. So, when that's part of your background, when that's part of who you are, these issues strike you in a more personal way. And you've seen what it can mean to people on the ground to have tribal sovereignty be something that their tribe has. And you see what it means to people to be able to have their culture, which for a long time flourished and then was said to be and enforced through law to be lesser than other people's cultures. It's good to see people advocating to restore that to its rightful place.
Thank you. I want to get back now, Greg. Right before we had a little break, you were talking about a case that concluded that the term Indian, and we use this term because that's the term that's used in the law and in the Constitution, the term Indian was thought to be political and not racial, but you've researched it, and what do you conclude?
Well, what I tried to do is figure out when the word Indian was put into the Constitution in the first place, what did people think that it meant? Was it political or racial? And what I came up with is that it's very difficult to separate them. That is, people at the time thought of it both thought about the category of Indian both as political and as racial. But I think it's important to draw a distinction here. So wider Anglo-American society undoubtedly thought of this category of Indian as a racial category. They, in fact, often talked about contrasted Indians with white people. But the people who were the political elite, the Anglo-American leaders, contrasted Indians not with whites, but with this other category that they called the U.S. citizens. So they thought of Indians as distinct as a citizenship category, distinct from U.S. citizens. And I think that's important when we see how this term is used repeatedly in the early statutes and treaties defining this area of law. It's usually in opposition to this idea of citizenship. And that signals that at least the people who were drafting the Constitution primarily thought about these questions in this political terms. That's not to suggest that this racial rhetoric didn't exist. It was widespread. But I think it's important to separate out the different kinds of discourses that these definitions emerge from.
So one response to Texas is to say there's a pretty good case that this is not racial, it's political or something else. I'd like to ask each of you to comment on another part of the case. We've been talking about highfalutin rhetoric here. There is this little kid. He's, I guess, 2 from what I've read. Often the law just has a standard, kind of what's best for the kid. And the foster parents have been caring for him. The birth parents in this case apparently want the foster parents to adopt him. How do we balance that? How do we think about that?
It's a tough issue, and it's understandable that it would divide people, even people who are often of the same political persuasion. But what's important to note is that what you point out is that often what we're going for in child adoption is the child's best interests. That's the paradigm that often rules. And ICWA is based on the idea that the child's best interest is the same thing as the child being with the tribe or being with at least a native family. Because one of the things that a native child gets, if a native child is with a member of their tribe or another native family, is the sort of cultural education that you might not get and that was very hard for Indian children to get, say, mid-century, when they were often placed with white homes.
This is Stanford Legal, and today we're talking with Jared Crum and Greg Ablavsky about Native American rights. Greg, you had something you wanted to add.
Yeah, I just wanted to add briefly. Often people, I think, are confused about ICWA, and they said that it mandates a particular outcome. I think it's important to stress that ICWA is primarily about process and procedure. So all of the preferences in ICWA can be departed from what the statute calls good cause. But the point is that there has to be a process and that the tribe has to be able to participate in that process. So it's not purely about what the outcome is. The law does not say this child has to end up with an Indian family. The law merely says that when that decision is made, the tribe has to have a seat at the table and they have to be part of these discussions.
And one of the things you mentioned earlier when you were talking about the kind of constitutional history is something that's always really interested me. And it's an issue that is coming up in a slightly different form this time around again, which is how the census handed out seats in Congress. So in the initial Constitution was lots of people focused on the notorious 3/5 clause, which counted slaves as 3/5 of a person for purposes of allocating seats in Congress. But Indians didn't count at all. Native people didn't count at all if they were not taxed, which essentially meant if they were still part of a tribe, as opposed to people who decided to just completely assimilate into U.S. White culture. And the other thing that amazed me when I first started looking at this, because I do voting rights related stuff, is that in Arizona, people who were tribal members weren't able to vote until 1948. Can you tell us a little bit about that history as well?
So I think it goes back to the conversation that I was having with Joe a minute ago, which is that because Native peoples were often assumed not to be U.S. citizens, they were placed outside the boundaries of American society. It's not until 1924 that all Indians are given U.S. citizenship. And as you suggest, Pam, it wasn't until much later that many of them got voting rights. And the reason for that was that they were understood to be wards of the federal government. That is, because of the extensive power and responsibility that the federal government had, the idea was that they couldn't possibly be interested or have a role in state politics. And so this challenge of figuring out Natives' multiple memberships, both within their own communities and as part of the broader society, that's been a real challenge because, again, the ideas of sameness and difference sort of play out in very complicated ways here.
Yeah, it does seem to me that it's almost as if members of tribes are getting the worst of both worlds. That is, it used to be that we said they were political and therefore they couldn't vote. And now we're saying, no, they're not political. It's a racial issue. And therefore the tribes shouldn't have any real say in how custody decisions are made about Native kids.
Yeah, I've seen that across the board, actually, that the categories get manipulated and changed, often in ways that harm Native interests. And I think we see that at the Supreme Court as well as in some of the lower court decisions.
So, Jared, you mentioned earlier that the project you were working on is a project for NARF, the Native American Rights Fund. So is there a lot of good legal coordination among tribes in dealing with these issues? Or on a lot of these issues, does it turn out to be one of the tribes ends up litigating the issue, and it's only very late on that other folks find out that this is an issue or a problem?
Well, as to the first part, I think the answer is often yes. You have the National Congress of American Indians, you have the Native American Rights Fund. Those organizations are old. So one is older than the other, but they both have a long and storied history. And there is coordination that goes on between them because a lot of tribes have common legal interests. That's not to say that tribes are all the same. There's over 500 federally recognized Indian tribes. So naturally, they'll sometimes diverge in their interests. But as to their coordination, I think the coordination, especially recently, has been broader perhaps than in the past.
We'll be back with more from our guests, Greg Ablavsky and Jared Crum, talking about Native American rights, next on Stanford Legal on Sirius XM Insight 121.